He is the founder of the leading eviction law firm in the state of California. He's been in the business for 44 years. They've done over 200,000 evictions. They specialize in residential and commercial evictions. And it's my pleasure to introduce to you. Oh, before I introduce him, I forgot one thing. I better remind you of this. Please wait. Please hold your questions. Hold your questions till he finishes, because Dennis is answering questions all day long. He knows your questions, and so he's actually going to talk about the things and probably answer your question. So if you ask your question now, you'll want to take it back. And anyway, so please wait till the very end, then ask the questions, and we'll have a live Q&A. So now I will introduce our speaker today, Dennis Block.
Thank you, Jeff, and good morning, everybody. Yes, I have been in business for 44 years representing landlords. Literally, we've done every kind of eviction case that you can possibly imagine. We've actually evicted, for example, airplanes from airport hangars. I have evicted boats from boat docks. Of course, in that particular case, the landlord wanted to serve a notice to pay rent or sink. So we've seen about everything that you could possibly imagine until now. I have never seen the legislation that has been promulgated at this time due to the pandemic that has tried to create havoc for every income property owner in the state of California. AB 3088, the so-called Tenant Relief Act, is truly a governmental assault on property owners. That's what it is. There is no governmental order that attempts to make one segment of society support another segment of society. And that's what we have here, that the burden of the pandemic, the financial burden of the pandemic, is forced upon landlords to support tenants. Now, if you have a tenant, for example, that truly lost his job, worked in the restaurant industry, was a nail salon, and legitimately would love to pay the rent but couldn't. Obviously, we think that there should be some governmental help, some safety net for that person. But where is it written, and how is it possible that the burdens of the pandemic shall be just placed on the shoulders of landlords? Why is that our responsibility? Don't income property owners have their own families to support, their own children, their own causes? But yet we're specifically required to support tenants. Now, while I just told you of a true abuse story where the tenant truly didn't have the money, but my position is, why is that the responsibility of the landlord? I can tell you that a day does not go by that I don't get a phone call from an income property owner where he says that his tenant has stopped paying rent for the last few months, and yet he just drove up in a new car. The abuse factor of people who are using the pandemic to legitimately get out of a valid debt, their rent, is off the charts. Even under the unemployment figures, they're saying that unemployment in the United States is 8%, 9%. So that means that about 92% of the people should be able to pay their rent. But of course, that's not what we're seeing here. And yet you're having this as a governmental legislation forcing landlords to solely support one segment of society. You can go to a market where people certainly need foods, and they're not suggesting that that the markets give away their foods for free, but that's exactly what we have here. In fact, under the governor's rule is, in the state of California, of course, that shops have to close, restaurants have to close, which means that they can't sell their goods or services. Well, think about it. What we have here in this state is that landlords are forced to keep their doors open and forced to give their services away at no charge. Now, if you listen to the legislators, our elected officials, they're going to tell you, hey, you're going to get that rent because that rent's deferred. Under the state law, that rent is deferred through generally March 1st, which I'll go into, of 2021. And then the landlord is free to try to collect it. Well, the truth of the matter is that it would be very difficult for landlords to collect at that point because the government is forcing us to file regular civil lawsuits, which will take a long time to prosecute. Will also involve trying to locate your tenant who might not be around. The truth of the matter is, I would imagine that maybe 80% of this, quote, deferred rent will never be collected by the landlord. So what the politicians have done with their fancy legislation is to basically make landlords donate rent to tenants, and that's what we have here. This statute is supposedly going to be over on February 1st of 2021, which meant that while the tenants could, quote, defer their rent, but we really know it's forgiveness, on February 1, landlords will be able to serve a standard 3-day notice to pay rent or quit. And if the tenant doesn't pay at least the February's rent, then the landlord could bring forth an unlawful detainer. As to all the rent owed through January 31st, 2021, that rent is deferred and the landlord can try to collect it come March 1. Again, the chances of collecting it probably will be very slim. And if you think about it, the period, which I'll go into, for AB 38 actually starts as of March 1st, 2020 and extends through January 31st, 2021. If that's the case, you're looking at landlords who are basically going to be without rent for an entire year. An entire year, ladies and gentlemen, landlords will be without rent. You could not imagine the legislature and our wonderful governor creating this law to create havoc on our industry. But can you imagine that it's going to potentially get worse? We have San Francisco Assemblyman David Chu. What a havoc for our industry this individual is. And what he wants to do is he wants to extend AB 3088, the Tenant Relief Act. He wants to extend it through December 31st, 2021, which would mean that landlords would basically be now 2 years without rent. So I don't know whether this will pass. My guess is that it won't pass, but clearly our legislative body has no love for income property owners and solely wants to put this burden on our shoulders as a result of this pandemic, where no other industry has to donate their goods or services to their customers except for the income property owners. Let's go over the key points. I've done that in previous seminars, but I get so many questions on it as to what's going on with AB 3088 and the Tenant Relief Act, as I call it, the governmental assault on property owners. The first point that I want to raise, which is so confusing for most of my clients and from most landlords who I talk to, is that if you have a local eviction moratorium statute from a local municipality, for example, the city of Los Angeles, the city of San Francisco, LA County, if there is a local statute dealing with the eviction moratorium because of the pandemic, landlords have to follow that statute. So, for example, if your statute states that, this is the local statute, and we'll just take an example for Los Angeles, rent is deferred for 1 year, which means that all rent owed from March through the end of January 2021 will be deferred for 1 year, which means that tenants don't have to pay it until February 1st, 2022, a whole year. In Los Angeles, of course, you would have to pay the February rent, February of 2021, but as to all that rent leading up to that date, literally it's deferred for 1 year. You can imagine trying to find that tenant after 1 year, or what the chances will be in terms of trying to serve him or even collect on a debt that's big. You know, the fact that you have a judgment against the tenant doesn't necessarily mean that you're going to be able to collect it. So we get this confusion, for example, like in San Francisco or in Los Angeles, where the landlords want to serve that 15-day notice that AB 38 talks about. But you see, you have to be mindful of the local jurisdiction. And if the local jurisdiction, such as Los Angeles, states that that rent is deferred for 1 year, well, the state statute doesn't kick in. So before you start serving any notices in accordance with AB 38, which I'll be explaining, make sure that you understand how your local municipality works. So, and a lot of cities have them, a lot of cities don't, but you have to understand what city your property is located in and what are the parameters for the local eviction moratorium, because those have to be complied with first, okay? We've already gone over the fact that they determined that this is rent deferment. The truth is it's going to be rent forgiveness. A lot of people believe that evictions cannot be brought forth at this time, and nothing could be further from the truth. For non-payment of rent cases, for example, any rent that was owed prior to March 1st, 2020, that would not be within the pandemic time, and you could serve a standard 3-day notice for that rent and then proceed forward with an eviction. You have to be mindful, though, that if a tenant hadn't paid rent for months, right now we're in the month of December, and in a 3-day notice, you're not allowed to ask for rent that is in excess of 1 year. So that means currently, if you had, let's say, a tenant who hadn't paid rent in a year and a half, and quite frankly, I hear that story all the time in my practice, right now you would be able to serve a 3-day notice, but only for the months of January and February. January and February would represent rents that are not longer than 1 year owed. So on that basis, you'd be able to serve a 3-day notice, but again, just for January and February. Even if they owed you December of the year 2019, you'd still only be able to serve a 3-day notice for January and February. But if you have a tenant, for example, that hasn't paid rent since January through this month, a full year's worth of rent, the smart thing to do in that situation would be to serve a 3-day notice just for January and February's rent only and proceed forward with an immediate eviction. The rules relating to the pandemic and AB 3888 do not apply to any rent that's owed from prior to March 1st of the year 2020. Now, with regard to, for example, the city of Los Angeles or San Francisco and any of the municipalities in between, if the tenant has not in any way, shape, or form indicated to you that that his inability to pay rent was not based on the pandemic, then in that situation you are free to proceed forward with an eviction. And that would require you to serve a 15-day notice. This is the period from March 1, 2020 through January 31st, 2022. If the tenant has not in any way, shape, or form has not indicated to you that, hey, I can't pay because of the pandemic, then you're free to proceed forward with a 15-day notice and commence an eviction. I'm going to get into that in a second as to what's required for a 15-day notice, but what we're going over right now is eviction cases that can be brought immediately. So, of course, one is any rent owed prior to March 1st, 2020, and that would be a standard 3-day notice to pay rent or quit. Or if the tenant has not indicated to you that it is subject to the pandemic as to the reason why, you certainly could bring forth a 15-day notice to pay rent or quit, and that's even in jurisdictions which have their own eviction moratorium, because the local jurisdictions do require that, hey, that the tenant didn't pay because of the pandemic. There are other eviction cases that can be brought right now as well, and that is any violation of the rental agreement. So if you have a written rental agreement, and maybe the tenant hasn't paid in the last 6 months' rent, but the tenant also has violated a term of his rental agreement. Maybe, for example, he brought in extra people. Maybe he has pets that were not allowed under the rental agreement. Or he made alterations to the premises. Maybe he installed a window air conditioner. Maybe he decided that he wanted to paint the walls black, and he did it without the landlord's written permission. In that case, we can bring forth an eviction right now. We would serve a 3-day notice to perform or quit, giving the tenant 3 days to comply with that notice. And if the tenant didn't, then we have the right to bring forth an unlawful detainer action. Under the state law, if you are going to proceed that way, you're going to also have to serve a 3-day notice to quit after that notice to perform covenants or conditions expires. So once you serve the 3-day notice to perform or quit and the extra persons are still there or the place wasn't repainted, the new law is requiring that you serve a 3-day notice to quit. Now that's for any property that is subject to statewide rent control. If your property is not, then you're free to just serve a 3-day notice to perform or quit. But if your property is subject to statewide rent control, AB 1482, then you'll also have to serve an additional 3-day notice to quit. But these are cases that we can bring forth right now. And as the old adage goes, there's many ways to skin a cat. So if in fact you have a tenant who hasn't paid rent in 6 months, you know you can't bring forth an eviction because it's COVID related. You can bring forth an action based on the fact that they've changed the locks to the front door. That's an alteration to the property. So that would be a wonderful case for eviction. Other cases that you can bring forth would be a termination of tenancy. That is, that you're not subject to a local rent control law or to a statewide rent control. Let's pretend it's just a single family house or it's real new construction. If you have a lease that terminates on its own terms, for example, the lease terminated on November 30th, 2020, as long as you haven't taken any rent for the month of December 2020, then that lease would give you the right to bring forth an eviction on the basis that the lease is over, you never extended the lease, and the tenant had no lawful right to remain in possession. So again, you might have a tenant who hasn't paid rent in 6 months, but his lease expired on November 30th. Well, again, another way to skin the cat, we're just going to start an eviction, not for non-payment of rent. We're not allowed to. But we can do it on the basis that the lease expired, and therefore we have the right to bring forth an immediate eviction action. I might add that under AB 38, the Tenant Relief Act, it does not apply to commercial cases. So if you have a property that is not subject to a local eviction moratorium for commercial cases, you can immediately bring forth right now, serve that tenant with a standard 3-day notice to pay rent or quit. And if that commercial tenant doesn't comply, you have the right to bring forth an immediate evictions. And yes, the courts are open. Yes, the courts are accepting lawsuits and giving us case numbers and allowing us to do trials, including the fact of even jury trials, which we've been forced to do in the last week and won them both, I might add. So those are the general ways upon which we can continue not forward with an unlawful detainer action. Again, if you have a tenant that is subject to AB 3088, where the tenant owes you rent and you're not subject to a local municipality, you have the right to at least initiate a 15-day notice to pay rent or quit. Which now leads us into, what is this 15-day notice to pay rent or quit? What do I have to do? What is it in reference to? And can I, at the end of the 15-day period, can I then bring forth an eviction if the tenant doesn't comply? Well, that is true, you can, but let's go over it. To go over it, we have to understand 2 time periods. This is all by our wonderful governor and the state legislators who created this statute. And the 2 time periods are called the protected time period and the transition time period. The protected time period is that period where rent would be owed from March 1st, 2020 through August 31st, 2020. The transition time period is from September 1st, 2020 through January 31st, 2021. Those are the 2 time periods. If you're serving a 15-day notice, you would have to, and you have rent that was owed in both time periods, you have to serve not 1 but 2 15-day notices. One for the protected time period, once again, that's from March 1, 2020 through August 31st, 2020. And then you would have to serve another one for the transition time period, which is from, once again, from September 1, 2020 through January 31st, 2021. In each of these notices, you have to state each month what rent is owed and when it became due. So let's pretend for the protected time period that the tenant owed rent for July and August, and the rent was $1,000 per month. So in that 15-day notice, you would put the total owed as $2,000, but you'd have to list it out that July 1st, $1,000 was owed, August 1st, $1,000 was owed, and therefore the total was $2,000. You have to separate what month was owed, what day of the month. And the same thing is true for the transition period. With that notice, and again, what I'm going to be talking about is that there's literally 4 forms total that need to be served on the notice. Many forms are combined all in one notice, but there's at least 4 different things that have to be contained in the 15-day notice. In our practice, we use actually 4 different forms, so there's no confusion. But if you are using a form from the Apartment Owners Association, which combines it, that is totally legal as well. But in the 15-day notice, which is very similar to a notice to pay rent or quit, the standard 3-day notice, you just have to individually list what rent is owed for which month. You also have to have an information sheet which advises the tenant of his rights under AB 3088. So for the protected time period, what it's going to say is that that rent from March through the end of August 2020, that rent is deferred. And that's what this information sheet says. It's deferred until March 1st, 2021. On that date, your tenant, actually it's deferred until February 1st, 2021. Your tenant would have to pay that, but if he doesn't, which of course he won't, you have the right to bring forth, not an eviction, ladies and gentlemen, a civil lawsuit, and that civil lawsuit can be filed as of March 1st, 2021. So once again, for the protected time period, no portion of that rent has to be paid. It is all due as of February 1, when the tenant has to walk over to you with those 6-7 months worth of rent, or 2 months as in my example, and they has to hand you all that rent on February 1. If the tenant doesn't, then you have the right on March 1 to bring forth a civil lawsuit. That lawsuit can be a small claims court lawsuit, or it can be a regular civil lawsuit. Small claims court has increased their jurisdictional limit unlimitedly for these types of cases. Normally, small claims court's limit is $10,000. In this case, it's unlimited if that's what you're seeking for rent for that protected time period. Now, while you can bring a civil lawsuit or a small claims court lawsuit, I'll tell you what you can't bring. You can't bring an eviction case. Even though the money was owed on February 1st, it is forbidden to bring forth an eviction case based on that time period. Now, why is that? Because written into the Tenant Relief Act, the governmental assault on income property owners, it states that that rent is now transmuted to a different form. It is now considered a civil debt. And if you're going to bring forth an unlawful attainder, it has to be on rent owed. If it's not rent, then you can't bring it. So they've already changed the definition of what the tenant owes you for that protected time period. So you cannot, on February 1 or March 1, bring forth an eviction on the basis of all that rent which is due and wasn't paid. You can't serve a notice for that and bring forth an eviction. All you can do is bring forth a civil lawsuit, because that, ladies and gentlemen, is not considered rent anymore. It's a civil debt. In addition to the information sheet that has to go with the 15-day notice, you also have to submit a declaration that the tenant can merely sign. That declaration basically says to the landlord, and that the tenant merely has to sign it under the penalty of perjury, that the reason why he can't pay the rent is due to the pandemic, that he is financially impaired as a direct or an indirect result of the pandemic. If he signs that declaration and sends it back to you, then again, that is now transmuted to a civil debt. There's nothing that you can do except to bring forth a regular standard lawsuit come March 1st of the year 2021. Now, if he doesn't bring forth that 15-day, if he doesn't bring forth that declaration within the 15 days, then you do have the right, as I mentioned earlier, to bring forth a civil, regular eviction lawsuit, because he didn't return that declaration within the 15 days. So you'd actually have the right to bring forth an eviction based on your 15-day notice. Again, we're talking about the protected time period. And then you would file that eviction lawsuit, you would serve that lawsuit, and technically you'd be able to get a judgment and have the tenant evicted for failing to comply with that 15-day notice. How did he fail to comply? Well, he didn't pay the rent, the full rent within the 15 days, and he didn't return the declaration within the 15 days. So the landlord at that point is free to bring forth a regular eviction action. However, they do have what they call a mulligan for the tenant, that if the tenant doesn't return the declaration within the 15 days, and as I mentioned, you have the right to bring forth an eviction lawsuit, you would serve that tenant with the lawsuit. But if the tenant then files with the court that declaration, which by the way was way late, certainly outside of the 15-day period, then the court has to set up a special hearing to determine whether it was excusable neglect, whether in fact the tenant didn't send you that declaration within the original 15-day period. If the court determines that there was excusable neglect, like he didn't understand, then the court forces you to dismiss your eviction case. So it's like they get a second bite of the apple. We have seen a few of these in my practice go by. In each case, we have been successful that the court didn't think it was excusable neglect, but we did have to do an extra hearing on that. But ladies and gentlemen, if you do serve your 15-day notice and the tenant doesn't either pay you in full within the 15 days or give you the declaration, I certainly recommend immediately going forward with this eviction case. It will really be a pretty reasonable path to evict that tenant. In addition to the 15-day notice and the information sheet that I talked about for the protected time and that declaration that merely the tenant has to sign and send back, you also have to include with that the governmental notice. That's 1179.04. It's a form. The website has it for the association, or it's also on my website. So that's basically the fourth document that needs to be served with the 15-day notice. That was for the protected time period. Let's talk about the transition time period. Once again, that's from September 1, 2020 through January 31st, 2021. For that time period, you have to serve a separate 15-day notice. It has to go with its own information sheet, which differs from the protected time period. You have to serve a separate declaration for the tenant to complete. And again, that governmental form. So what is the difference between the protected time period and the transition time period? For the transition time period, the tenant either pays the rent in full or signs that declaration, but there's now an additional requirement, and that is that the tenant has to pay 25% of the rent. So if, for example, we're talking about the rent owed for November, December, so therefore $2,000 was owed, and you served that 15-day notice for that transition period with the declaration, with the information sheet, the tenant would then sign the declaration potentially and send that back to you, but he would owe 25% of the rent. 25% of the rent would be a whopping $500. Now, logic would tell you that that 25% of the rent, that $500, would be owed within the 15 days. But remember, I said logic, and there's nothing logical with regard to this statute. That 25% is due on January 31st, 2021. January 31st, 2021. So if you get the declaration back, he doesn't have to pay that whopping $500 that he owes until January 31st. Now, I can tell you, though, if he doesn't pay it on January 31st, you're free to file an eviction lawsuit based on your 15-day notice come February 1st, 2021. February 1st, 2021. Now, again, I have to keep saying this. Everything I'm telling you is accurate, but if you've got a local jurisdiction which has their own eviction moratorium laws, you're not allowed to serve a 15-day notice based on the provisions of that municipality. So please check that first. But assuming you're not stopped by the local municipality, the tenant would have to pay 25% of the rent by January 31st. And again, if he doesn't, we have the right to bring forth an eviction come February 1. Now, again, February 1, he's going to owe you the February rent in full, and you would be able to serve a 3-day notice for the full amount on February. But if he didn't pay the 25%, certainly you could start the lawsuit without serving any other notice. Your 15-day notice would be the initiation of that lawsuit. But then comes the question, well, wait a second. You said 25%. What happened to the other 75% of the rent? When do I get that paid? Well, the truth of the matter is the legislators in AB 3088 has now defined 75% of the rent, that would be $1,500 in our example, as a civil debt. Again, it's not rent anymore, it's a civil debt. And again, you could sue for that rent in a civil lawsuit come March 1, 2021. March 1, 2021. And of course, you could combine that with the protected time period. But if in fact the tenant moves away or is gone, and you don't know where he is, or you just merely get a judgment, there's no way that you might be able to collect it if the tenant doesn't have any wherewithal or any assets. So basically what we're talking about is rent forgiveness. Don't let the politicians confuse you that this is merely rent deferment. So that's the basics of AB 38 with the service of not one but two 15-day notices, always keeping in mind that you have to be cognitive of the local eviction moratorium in your area. And if, of course, that trumps the Tenant Relief Act, if it's giving the tenants additional rights. Now, one thing I also wanted to talk about is 15 days. How long is 15 days? Most people would think, well, that's pretty simple. 15 days is 15 days. But of course, that would be a logical thought. And again, there's nothing logical about AB 3088. 15 days is not 15 days. It's 15 days excluding Saturdays, Sundays, and legal holidays. So basically, a 15-day notice is 22 days for the tenant to comply. That's true for both the permanent time period, or the protected time period, and the transition time period. So don't race out and think that the tenant didn't send you the declaration within the 15 days unless you've truly counted it out for excluding Saturdays, Sundays, and legal holidays. But truly, if in fact you have tenants that aren't paying rent, I would obviously recommend that, number one, you check for your local jurisdiction. If not, serve your 15-day notices and bring forth that unlawful detainer. If you guys want to call our office, we're free to answer your questions. Our office number is 1-800-77-EVICT, 1-800-77-EVICT. That's EVICT. You can also check us out on our website, which is evict123.com. We have all of our legal issues there and all of our podcasts, including the videos that we've taken on this particular subject. We're going to open it now, Jeff, to questions. If you guys have any questions, I'll do my best to answer as many as I can. But once again, you can always call our office at 1-800-77-EVICT, and we're happy to answer them. So, Jeff, you want to lead us off with our first question, young sir?
Great, yeah, thank you. And one thing before we do that, I just wanted to mention that you have a really good article in the AOA magazine every month, and just wanted to thank you for contributing every month and just being with us for all these years. And this month in particular, I thought it was pretty funny that. Should I start over? Okay, I'm going to start over because I didn't have my mic on. Excuse me. Yeah, I just was saying that Dennis, he writes an article every month in the magazine. And this month, he cracked me up because the last question that he has here, he has a Q&A that he does. And just like you're listening to this Q&A right now, there's one that's in the magazine. You can catch it online, or if you're a member, you can get it. But I really like that last question that you asked. And you'll have to look at the article to see what it is. But what I like about you is that you still have a sense of humor, even though you're dealing with such horrible things and such pain every single day. So just love that about you. And also, one thing that I did mention at the beginning is just the thing of generosity. And one thing as AOA, what we would like to give you, if you have not had a site inspection, we would love to give you 4 4-star credit reports if you complete the site inspection. We have Angelica. She can coach you up so that you get past the site inspection, and those 4 4-stars basically equal the cost of what a site inspection costs, and so we'd like to do that for you. And one of the things that you mentioned the civil judgment. You have to take it to civil court. So people could get a judgment for the $1,500 in your example that's owed. Just curious, if they're still in the building, can you report that to the credit agencies if they're still in the building, but you did get a civil judgment on that?
The answer would be yes, of course. Whether they're in the building or not doesn't detract from your right to report that as a judgment against your tenant. Also, you'd be able to attempt to do the collection on the tenant.
Cool. And just for everybody to know that we do have a double whammy eviction report, and in that eviction report, it shows the civil judgments. And so if you don't think it's worth the time, just get the civil judgment, because at least the next guy that comes across this person, they can be reported where it's on their credit, and it can also show up on that civil judgment. So that's one thing that you'll want to do. And anyway, here we have, I'm going to take a question from Jack Mathis on YouTube. And basically he's asking you to summarize everything for him, because he has two different things going on. He says, can you tell me exactly what needs to be served for a tenant under rent control in LA, under rent control, who missed several months of rent in April, May, and June, and then also part of November? So it's combining both of those time periods together.
So again, for the first period, you didn't serve a separate 15-day notice. You said the months were from April to June. Was that it, Jeff?
Right, April, May.
So
and
from
June.
April to June, you'd have to serve one 15-day notice. You'd have to serve an additional 15-day notice for that partial load for the month of November. Again, I'm assuming you're not subject to a local jurisdiction, and assuming you're not, then you could serve both of those notices. You'd have to serve it with 2 declarations. And I put on ours the actual date. So I would say, like, from April to June, you have to declare that you were impacted by the pandemic, and then another declaration for the month of November, which says for the month of November you were. Because you could see where somebody, for example, maybe didn't have a job through June, but in November, he's been working now for a couple of 3 months and had no problem paying the rent, he just didn't. So we want him to declare for both of those periods that, in fact, he was affected by the pandemic. In addition, you have to serve the different information sheets and one of those governmental forms dealing with the Civil Code 1179.04, actually Code of Civil Procedure 1179.04.
Okay, great. Thank you. And here's a good question from Glenda. I need my kid to move into my condo. We're in LA County. What notice do I give my tenant? And what's the first day that I could serve it?
LA County versus a specific city. So if it's, for example, the city of Los Angeles, then there are no such thing as no-fault evictions right now. So you wouldn't be able to bring forth a notice to quit on the basis that you or your son want to move in. If you're not in an area which has a local municipality which prevents that, for example, in LA County, if you're in an unincorporated area of LA County, or you're in a city in LA County that doesn't have rent control, you are free to serve that notice on the tenant. Condos are not subject to any rent control for the most part. So you'd be able to serve a 30-day or a 60-day notice to quit on that tenant and proceed forward with an eviction. So I would need more clarification as to what city, but it's certainly doable in that situation.
All right, here's one from Everland, California. My client is in the process of buying a 3-unit in Seal Beach. So there's a specific. And they want to move into one of the units, which is the only 3-bedroom unit. This will be the second home, not a primary home. What would the process be for that?
Well, if you're if you're in Seal Beach, you are subject to what they call statewide rent control. That's under AB 1482. It's interesting that you just threw a monkey wrench in there with the last sentence, which states that it's not going to be a primary residence. The code section under AB 1482 says you're allowed to move in as a primary residence. So you might have trouble evicting one of those tenants unless it's your primary residence. Under the code, you'd have to give relocation money, which is equal to 1 month's rent. And I'd have to check this again, but I'm pretty certain that AB 1482 says you can move a tenant out, but it has to be your primary residence. Another thing that you could do in the same situation, which is probably what you're going to do anyway, there's another ground for eviction, but you'd have to wait until February 1st, 2021, which is coming up relatively soon. And that is you just need to do renovation of the unit. Renovation which requires a building permit, like a plumbing permit or a electrical permit. So you probably were thinking about, in this unit, probably redoing the kitchens or the bathroom. So notwithstanding the fact that it's not going to be your, quote, primary residence, you would be able to ask that tenant to leave, pay the relocation money, which is 1 month's rent, and then do that renovation, which you probably were going to do anyway since you're buying this place. And then you'd be free and clear to ask this tenant to move. But again, you'd have to wait until February 1, 2021. Again, there's always different ways to skin the cat here.
All right, this one's from Monica, and they have a property in Upland. How difficult is it at the moment and foreseeable future to get a tenant, they're current on rent, to move out or evict them if they don't want to move when the property is being sold?
Okay, if the property is a single-family residence, then it's not subject to any rent control. So right now, today, you can serve on that tenant a 60-day notice, assuming the tenant has lived there longer than 1 year, or a 30-day notice if the tenant has lived there less than 1 year. And you can do that right now, and then at the end of that time period, if the tenant is still there, you could bring forth an unlawful detainer action to evict them. There is nothing under the law preventing you from doing that.
Great. All right, next question. All right. Will the recent law that allows eviction as of January 31st, 2021 change the latest state shutdown order?
I don't think
with
so.
the latest state shutdown order.
In other words, with this latest shutdown order, are they going to do anything different? Right now, this statute with regard to the payment of the rent ends as of January 31st. That's the end of the transition time period. And this is codified under the Code of Civil Procedure 1179.01 and continuing. So I don't think it's going to have any impact. They would have to do another code section. I don't know how much more grief they can throw on landlords. Our famous friend David Chu, the assemblyman, is trying to extend it towards the end of December. But I have hope that it won't, and that we'll be free and clear to get back our property. You know, the property rights is what this country was founded on. And you can talk about freedom of speech and freedom of religion, but the truth of the matter is people came to this country for property rights. And we just see an attack on people's property rights in this state and a lot of other states as well. But again, you're free to do so.
Great. We have Monica on YouTube. What can we do to ensure that new tenants will pay?
That's a good question. I have clients who call and say, listen, if I'm afraid to rent this out. If I rent this unit out, then I can get my rent, and then the next month they'll claim COVID and I'll be without rent for so long. So I think I'm just going to leave it vacant. When I hear that, I can certainly understand why they're saying that, but I can tell them one thing that's certain. If you don't rent out your units, I guarantee you, without question, you'll make no income. That's true. You're not going to make any income. At least you have a chance if you rent it out. So what can you do in terms of making sure that the guy doesn't play the COVID game, and that's what it is, the COVID game, the next month after he moves in? Well, number one, you've got to do a wonderful credit check through this association, which will really tell you the character of the person who's moving in. You want to make sure that you get a maximum security deposit. That would be 2 months, minimally, plus the first month's rent. So it's a total of 3 months upon move-in. Since the statute is subject to be over as of February 1st, at least you'd have the rent in your pocket in advance. Now, I have had some landlords that say, well, gee, can I get more than that? And the answer, as an advanced rent, and the answer is yes, you can. It's an unusual law, but you can get anywhere from 6 months to 12 months rent in advance. Not less, So you can get either the first month's rent and a 2-month security, or you can get rent that in advance from 6 to 12 months in advance, plus the security deposit, which could be 2 months. So if you're very worried, and if you can get your tenant to commit to putting up that rent in advance, then of course you would be protected. But I think you're okay with that credit check from the Apartment Owners Association, and of course getting the security deposit. And as I had experienced just this 1 week, make sure that you get your tenant to sign all the documents before you give them the keys to the property. Because once they're in, they have all the rights and you don't. So make sure that they do sign that rental agreement, and you fully do the credit check, go over all of his sources before handing the keys. Don't let them walk in to measure for drapes or anything else unless you're standing there, okay?
Yeah, and thank you, Dennis, and back when this started, when COVID started, we changed the rental application that we use to include the question of whether or not they owe rent to their landlord. And I think that's an important question to have in writing, because if you have that in writing and they say that they don't have any problem with that, and then they do, you can go back and that would be grounds for eviction. But use a good rental application. And also another thing that I'd like to mention is check that previous address history. That's part of the criminal. We have a 3-in-1 criminal report that's part of it. Please do the due diligence on that. And one other thing is there's a lot of fraud. And so those bank statements and those pay stubs, they can be fraudulent. And we're seeing a real rise in that. And within this next month, we plan on introducing a service where you can do document screening. So you have your tenant screening, but then there's also the document screening. So we hope to offer that to you guys pretty soon as well. All right. Thank you, Michael, for that question. And on to the next one. And all right, next question, please. Okay. I'm not getting it. I'm going to open it up myself here. Give me a moment. There we go. From Hermosa Property. In October 2020, we did not give the new notice after watching you on a webinar. Can we go after the 25% money in March 2021 if we didn't? We had received and gave the COVID notices before that.
Not exactly sure I understand the question. There was a COVID notice, that state form that had to be given to each tenant in the state of California by September 30th. If you didn't give that form, and again, it's on the association's website or on mine, you can just give it to them now. There's no harm, no foul to it. If you're serving a 15-day notice to pay rent or quit, you do need to serve that with it. That's one of the forms of the 4 that I talked about. You were talking about the month of March. Remember, March through August is the protected time period. So you're not entitled to 25% during that period. You are entitled to 25% from the period from September through January 31st, 2021. And in that time period, they would owe you 25% of the rent, assuming they signed the declaration, and they would owe it by January 31st. And if not paid, then you could bring forth an unlawful detainer.
Alrighty, here we go. Okay, here's from MG. If I served a notice to pay or quit and can't evict due to moratorium, do I continue to serve a notice each month or just wait to give a notice of arrears each month? The property is LA RSO.
So let's pretend, for example, and this is a good question, let's pretend, for example, in the month of November, you realized about this 15-day notice, so you served one 15-day notice for the period of September, October, and November. And the tenant signed the declaration and sent it back to you. should you do one for December and January? And the answer is absolutely. Do an additional 15-day notice for December, or and another one for January. You might want to just wait till January and include December and January all in one notice. So now you've served two notices, two 15-day notices, and 25% of the rent for that 5-month period that we just discussed would become owed as of January 31st. If not paid, you could then proceed forward on both of those notices. But it is important to serve the notices for the remaining portion of the transition period. And the reason is because you want to get your 25%, and which will become due on January 31st. So if I only served a 15-day notice for example, for September, October, November, on January 31st, 25% of those 3 months, the tenant doesn't have to pay anything more than that. So let's serve another notice for the December and January. So now the tenant is at least, for those 5-month period, paying 25% of the rent that's owed. Good question.
Great. And here's a question about increasing the rent from Mario. He has a duplex in Huntington Park. They have a long-term tenant. What process do I need to follow to inform the tenant correctly of a rent increase?
Okay, you can serve a rent increase right now, unless there's a local moratorium. For example, Los Angeles, which has banned rent increases for 1 year. Did I tell you how much I like it, Eric Garcetti? Have we gotten into that yet? Okay, we'll drop that for the next seminar. But you said it was Hermosa Beach.
Right.
So for that area, you're subject to AB 1482, which is statewide rent control. And nothing prevents you from doing a rent increase right now. So what is the rent increase? So the rent increase, you can do one per year. It's 5% plus the CPI. They actually just changed the definition of CPI when they instituted AB 3088. It used to be one for the entire state. Now it's for the local jurisdiction. For that area, all of Los Angeles County and Orange County, the CPI as computed of April of each year. In April of 2020, it was 0.7%. So you're entitled to, for that particular unit, serving a 30-day notice to change the terms of the tenancy to increase the rent a total of 5.7%. You're going to have to check, if you're in different jurisdictions, what the CPI is for your jurisdiction as of April of the year 2020. And again, it switches every year in the month of April.
And that's a 30-day notice.
It's a 30-day notice.
Great, thank you. Okay.
I might add, if you're ever raising rent, let's say you're not subject to rent control, there's another little poison pill in there. It used to be that if you were raising the rent 10% or less, let's pretend you have no rent control, so you can raise it to whatever you like. If you're doing it 10% or less, it's a 30-day notice. And most people think, and they're wrong, that if it's more than 10%, that you have to serve a 60-day notice. Well, that law got changed by our wonderful governor. It's now a 90-day notice. So if you're going to go above 10% in any 1 year period, you'd have to serve a 90-day notice of rent increase.
Okay, great. Here's Jennifer on YouTube. I want to know about LA City eviction moratorium, where there is rent control. What can be done if a tenant does not let you know they are affected by COVID 7 days after the rent is due?
Okay, well, Los Angeles doesn't have a, quote, any 7-day period. Other municipalities do. Los Angeles says if a tenant in any way, shape, or form has indicated to you that the reason they're not paying the rent is because of the pandemic, then the landlord can do nothing, zero. Okay, you can't serve a 15-day notice. You can't serve a 3-day notice. You might find another way to rid yourself of this tenant, for example, extra people or an animal or an alteration to the property, etc. But you can do nothing. You're going to have to wait until February 1st of the year 2021. On that date, the tenant will owe you February's rent only. When does that last rent that he didn't pay for, let's pretend from March of 2020 through January of 2021, when would that become due? That would become due in 1 year. 1 year. So that means on February 1st, 2022, If the tenant hasn't paid the rent by then you'd actually have the right to serve a 3-day notice and go forward with an eviction. So that's what the city of Los Angeles, it's very, very harsh in the city of Los Angeles. And again, even if the tenant said nothing to you, but you had reason to know that the tenant's inability to pay rent was because of the pandemic. For example, you knew the guy worked at a restaurant and you knew the restaurant was closed. Even though the tenant said nothing to you, you can't serve anything. Now, if in fact you had no reason to know, in this example, that the tenant didn't have an inability to pay the rent, then you could, and he never told you, never breathed a word, no skywriting, no text messages, no nothing, then in that situation you could serve that 15-day notice. If the tenant doesn't return the declaration or pay the rent in full, then you'd have the right to immediately commence the eviction action after that 15-day period.
All right. Now here's one from Howard. When does the freeze on rent increases for a rent-controlled property in the city of LA expire?
I think we just mentioned that that's 1 year. So February 1st, 2022, you'll finally be able to do a rent increase on your tenants.
All right. And let me see. Here's Rosalie. I am selling my property. How am I going to let the tenant know that the new owner wants to move in?
Well, you're not mentioning what locality or what type of a property. I'm going to take a guess that it's a single-family home and that it's in a it's not in the city of Los Angeles, which has their own rules. So in that situation, number one, there's never any requirement that an owner of property tell the tenants that they're selling or in the process of selling. You can do that if you like, but there's certainly no requirement. The only reason why, let's say for a single family home that you might want to do it would be a ground to evict that tenant even during this pandemic if in fact you're selling a single family home and the purchaser intends to move in as his primary residence. If that is the case, then the landlord can serve a 30-day notice, not a 60, even if they've been there longer than 1 year, a 30-day notice on the tenant where they would have to write the reasons in the notice that the property is in escrow. It's not just that I'm thinking of selling it or I'm going to put it up for sale. It has to be in escrow and that the purchaser intends to move in as his primary residence. So that would be the only reason why I would want to tell the tenant that the property is being sold and that the purchaser wants to move in.
Okay, great. We have Amy. Can you do a termination of tenancy if it's a month-to-month rental agreement and not a year-long lease?
No, you can't. It has to be a fixed-term lease that's expiring by its own terms. So, for example, if you have a lease that commenced on, let's pretend, December 1st of 2019 and was over as of November 30th, 2020, then you don't have to serve the tenant any notice. You might want to send them an informal letter that, hey, I'm not renewing, and get out. Of course, if this is a rent-controlled unit, you can't do that. But if it's not subject to any rent control, then you can merely tell the tenant, I'm not renewing, and please vacate at the end of that time period. But if you're on a month-to-month tenancy, you can't just use termination of tenancy. You'd have to serve either a 30-day notice or a 60-day notice. And again, you'd have to be in a non-rent controlled area in order to be able to terminate a month-to-month tenancy.
Okay, on YouTube, we have Batul. If City of LA removes the moratorium February 1st, does this mean that they remove the halt on the Ellis Act too, on the no fault?
On the what, please?
On the Ellis Act.
Yes, the Ellis Act is where, for our listeners out there, is where you want to permanently remove the units from rental housing use. So you have a duplex and you know if you knock the thing down and put up 6 condos, you're slated to have an economic gain in that situation. So you have the right under California law and even under the City of Los Angeles law to remove units from rental housing use. So you're permanently removing them. So it's not like you're just going to tear it down to the studs. You actually permanently have to remove it. Then you have the right to ask the tenants to leave. Right now, those types of evictions are forbidden in the city of Los Angeles, but they will become available come February 1st. So for all those pent-up investors out there who bought property with the idea that they wanted to do redevelopment of that property, you can go through the Ellis Act at that time, and of course our office is an expert at doing that.
Great. And here's a good question from Sierra Property. Can you still give a 90-day notice to tenants who are on Section 8 and not under the state rent control?
You can if you're not subject to any local rent control jurisdiction. So if you're under AB 1482 statewide rent control and you have a Section 8 tenant, well, AB 1482 requires that you have to have cause to evict.
All right, here's the next one. Can you evict for not signing a new, like, and similar rental agreement?
In other words, even in most rent-controlled areas, if you have a lease which has terminated, let's pretend that example, November 30th, you could go over to the tenant on December 1 or send it beforehand, say, I need you to sign a similar lease for the same term for an additional year. If your tenant refuses to do so, that would be grounds to evict that tenant, even under rent-controlled areas.
Okay, and here's one from Val. I have a tenant that is paying slowly and 3 months behind. Wouldn't it be best if I kept taking her money until mid-2021 and then evict her?
I would say absolutely.
Mm-hmm.
Yeah, take what you can get now. And then on February 1, you're free to do a full eviction because they're going to claim that the reason why they're slow paying you or partial payments to you is because of the pandemic. So we have to deal with AB 3088.
Okay, here's a question from Ginger. Let's see, that one disappeared. Here's one from Monica. City of Ontario in California is having landlords pay for business licenses on all rentals. Shouldn't they be considered commercial then?
Well, the fact that a municipality is trying to extort more money from its residents and property owners is no surprise. But whether now that's magically because they're asking for a business tax, that now your residential property is now considered commercial is not going to be believed by anybody. It's a residential property, and they just want to impose a license. You know, you can have a license on a commercial car that you drive for your business, or a license for a regular passenger automobile that you use for your own personal use. And obviously it doesn't change it because you have a license.
Wow. Okay. Jeepster on YouTube. What is the likelihood you will start a lawsuit against the city for illegally interfering with a contract?
I think those lawsuits have already been filed by different organizations, so we're keeping our fingers crossed. There was an initial skirmish at the trial court level. This was federal court, which the judge did not side in favor of the landlords. This was based on the statute that Eric Garcetti implemented. But we didn't think that the trial court level would be sitting there and making new laws. So, of course, that's being appealed, and we're hoping the appellate level that we'll get a better ruling.
And for the city of LA, this kind of came up. For the city of LA, we cannot bring a 15-day request to pay until 2020. We can't evict for lack of payment. Can we go to small claims court? Do we have to wait till 2022 to go to small claims court?
Yes, I mean, under the insane law as promulgated by Eric Garcetti, and I mean insane, that rent is not going to be due until February 1st, 2022. So basically, in most situations, I would say 80-85%, you just lost that money. And I think we should all, maybe me and you, Jeff, let's go. We'll go over to Eric Garcetti's house right after this broadcast. And in fact, you said you were going to buy me lunch, I might add.
Oh, let's do it.
I appreciate that. And then we'll go protest in front of his house.
All right, let's fill our stomach and then go protest for a while. And here's one from Albie. Can I serve a 3-day notice for non-payment of rent for a commercial property in the city of LA?
And the answer is no.
No.
So while it's legal under the AB 3888, because that doesn't involve commercial cases, the city of Los Angeles has their own rules with regard to the owing of money for commercials, and that's deferred. So that's going to be deferred until, again, February 1st, that commercial tenant will owe the February's rent, but for commercial rent, all that rent that was deferred from March through January 31st, 2021, that rent will be owed in 3 months, not 1 year. So if we're talking February 1st, February, March, April, it'll become due as of May 1, 2021.
Great. Okay, here's one from Jeff. We have a parking tenant who hasn't paid for their parking space. Do we have to file an eviction or can we just tow the car?
If you have a separate rental agreement for the parking, then no, you can't just tow the car. You'd have to go through a regular eviction action.
Okay. All right, Steve, if a tenant owes back rent and all the notices were filed, the tenant moves out on December 15th. When can you file suit for back rent?
If the tenant filed the declarations and sent in those declarations, which I think what happened in that situation, the way you're reading the question, then you're going to have to wait until March 1. But what happens if the guy, moves to Alaska, or Calgary? Where are you going to be able to find him? And if he does move out of state, how are you going to collect? You're going to have a California judgment, so you're not going to be able to collect in a different state, right? Let's pretend he stays in California. Well, you can file that lawsuit on March 1st, but then the first thing you got to do with a lawsuit is you got to serve him. Well, where is he? Did he leave you a forwarding address? You think he'd left you a forwarding address? Of course not. So we could call the governor. Maybe his office would be able to tell us where the guy moved to, because we're going to need to have his address in terms of serving him. So that's what I find is preposterous with regard to this law, where they're claiming that it's deferred rent. There is nothing in life that this rent is going to be deferred. The state has now made rent forgiveness and put it all on the backs of landlords.
All right, and here's Paul. I have a tenant who passed away and had 2 adult daughters living in the unit, not on the lease. Do the daughters have a right of possession, and can I have them sign a rental agreement at the same rent?
So the issue is whether this is under rent control or not. If it's not under rent control, you have a simple basis for evicting because you can just terminate the tenancy, serve them with a notice to quit. If you're under rent control, the issue would be, did those adult daughters move in after the father, or were they on the lease? Under rent control, if they all moved in together, then they're going to have tenants' rights in most jurisdictions. If, in fact, they moved in after, and assuming you never accepted rent from them, because that would have created a tenancy, then we can serve them, which I've done many times in the last month, a 3-day notice to quit, because they're unauthorized subtenants at the end of the lease term. They are unauthorized subtenants at the end of the lease term. The term is over, the lease, because the guy died. So that means that lease is over. We never approved you to live here. We never put you on the lease, and we never took any rent from you. So it's a 3-day notice to quit, and those cases move forward. So that's a good case.
Okay, here's a question from John. I have not given my tenant a 15-day notice, but they still gave me a declaration. Do I still need to abide by the rules of 3088?
And the answer is yes. If they gave you the declaration, you have to abide by the rules of 3088, which means that depending on for what period, protected or transition, that no rent would be, it would be considered a civil debt and wouldn't become owed until March 1, where you could finally bring forth that lawsuit on March 1.
Great. And okay, here we are, Hermosa property for the city. Wait, okay, I don't know why. Let me see. For the
Think you did
city
that
of
one.
LA, we can't evict for non-payment if they fill out the proper documents. Correct? Can we, or we cannot collect the 25% until 2022 in the city of LA?
All right, so you see, that's where the confusion comes.
Yeah.
Because people look at the state law, and with this 15-day notice and 25%, but remember, and I said it right at the beginning of our discussion, if there's a local jurisdiction, like, for example, Los Angeles, has nothing to do with 15-day notices. It has nothing to do with 25% of the rent becoming due. If the tenant has indicated to you in any way, shape, or form that the premises, his reason for not paying the rent was because of the pandemic, that rent's deferred for 1 year. It has nothing to do with 25%. So you wouldn't be able to even ask the tenant for the rent until February 1st, 2022, okay? And then you'd be able to serve a 3-day notice on that. It's not, by the way, if you didn't get the declaration, which might be a trick that we can use even though it's so far in the future, if you don't get the declaration from the tenant, then that's still rent that doesn't comply with the state law because it's not applicable to the state law. So on February 1st, 2022, you could actually serve a 3-day notice for that rent and proceed forward with the eviction. But of course, that's so far in the future, who knows what's going to happen.
Okay. What if I mistakenly served 2 15-day notices in LA, but the tenant immediately signed the COVID declaration?
Well, then you're basically, the rent is still deferred for 1 year, any way you look at it, because you're still in the city of Los Angeles and you shouldn't have really served a 15-day notice. Technically, you've committed a civil wrongdoing and the tenant can sue you, believe it or not, based on the city statute.
Wow. Okay. And Radoslav, I served all 4 papers and the tenant never responded back to me. He responded to court and now he's lying, saying that I didn't give him the rent protection sheet. What's the next step?
I've never heard of this, that a tenant would lie in court. Has that ever happened? I mean, they all come in and they tell the exact truth, right?
Oh.
I mean, all you can do is when you get to court is you show the paperwork that you got. You might want to explain where you got the paperwork from to show that, in fact, it was served. Depending on what judge you receive, most judges would think that you served the paperwork correctly. But quite frankly, there's so many pitfalls in these types of cases that you really have to be on your game. There's literally 50 things that can go wrong, and any one item can have you thrown out of court. Always best to use a professional.
Here's a question from Raphael. I understand that eviction cases are now proceeding in non-COVID related cases, and they take approximately 4 to 10 weeks. But is the sheriff's department actually serving the eviction notices?
They have been serving eviction notices, but I heard that, and this my office manager just told me this yesterday, that they're not doing any lockouts between today and December 31st. I don't know whether that's a holiday thing or it might be something from the CDC, but I don't think it's going to affect too many people. It's only another, 14 days away.
All right, here's one from Neo. How can I pursue money from an undocumented tenant?
Well, I mean, I'm assuming you have a judgment, so you have to do debt collection and skip tracing. That's what our firm does because we do collect on judgments. And even without a social security number, we can usually locate a social security number, assuming the person has one. And usually we can locate a place of employment, assuming they're working or bank accounts. So we're pretty successful in attaching bank accounts and garnishing wages. But again, if a tenant doesn't have any wherewithal or the person who you have the judgment against doesn't have any assets, then quite frankly, you're not going to be able to collect.
Right. And so for the undocumented part, I think that was if they're undocumented, then they're not going to have a social security
I'm not
number.
sure what they mean by undocumented. Are we talking about an illegal alien, or we're talking about somebody that you don't know his documents? But in either event, obviously, it's going to make it more difficult.
Right. And all the more reason to have them fill out the rental application completely and get bank information, right?
And that is true.
All right. And here's another question from Sierra Property Management. Can you still give a 90-day no-cause notice to a tenant under Section 8? The property does not fall under state rent control.
If the property doesn't fall under state rent control, you're certainly free to do that.
Okay, great. All right.
I might want to state something, though, as a clarification. My understanding of AB 1482, statewide rent control, is that Section 8 does not apply to that section. We've had disagreements with other attorneys and the courts with this. If it doesn't apply, then you're free to give a notice to terminate a Section 8 tenancy with a 90-day notice. But if it does apply, then of course you would have to have good cause and you couldn't just do that.
Okay. And here's one from Joe. Can I issue a change to a month-to-month rental agreement regarding the way the rental payment is to be paid in this?
Nothing prevents you from changing, for example, the due date from, let's pretend it's due on the 10th and you want to shift it to the 1st. Nothing prevents a landlord from serving a change of terms of tenancy that I want rent paid to a bank account, direct deposits, or to a different location. So that certainly is permissible.
Okay, here's one from Aletha. My tenant hasn't paid for 3 months, claiming he lost his job due to COVID-19. Can I sell this condo?
Well, you can always sell a condo, whether the tenant is there paying rent or not there paying rent. You can always put a condo up. I think what the question is, can I get the tenant out? Okay, so condos are not subject to statewide rent control. And if you're not subject to a local, you can always just serve the tenant with a 30 or a 60-day notice to vacate. However, under the current eviction moratorium, you can't get a judgment until January 31st. But if you're serving a 30 or 60-day notice now, you wouldn't get a judgment by that time. So you're free without any reason to evict that tenant from that condominium.
All right, here's one from Candace. When can we increase rents in the city of LA?
It's going to be in 1 year. That's February 1st, 2022. Thanks to your mayor.
All right, yeah, thanks, right. Amy.
And I'm sure he's at a restaurant right now having a good time.
French Laundry, here we go. Can I serve a termination of tenancy if it's a month-to-month tenancy and not a lease?
Well, you can serve a termination of tenancy, which would be a 30 or a 60-day notice. But again, you're subject to all these rules if you're in a rent-controlled area, if you're subject to statewide rent control. If it's not subject to any rent control, you're certainly free to serve a 30 or a 60-day notice.
All right, here's one from JP. I have an SFR in LA with a Section 8 tenant. I have submitted plans to scrap and build and should have a permit in the next 30 days. Can I evict the tenant?
Absolutely. You're not subject to any rent control, and under Section 8 rules, you can evict the tenant just based on economic reasons. This is certainly an economic reason. So if you serve the proper notice on the tenant, a 90-day notice with the reasons stated in the notice, of course, mail a copy to your Section 8 advisor. And then at the end of the 90 days, if the tenant is still there, do you know what they need to do, Jeff?
What do they need to do?
They need to call me.
Right. And your number and
1-800-77-EVICT. We're going to go for a few more because I don't want to fall over here on camera.
Right, and also, and also your number, Dennis, is in the YouTube and the information. If you click there, they can see your phone number. They can see your web address there. So definitely give him a call. Yeah, let's just let's find one or two more, maybe people that haven't asked questions before. Here's Mary. If I were to sell my single rental house in Altadena and one in Pasadena, can I just move my tenants to a 30-day notice to move out?
If they've been there longer than 1 year, it would be a 60-day notice. If they're there less than 1 year, and we're assuming they're on a month-to-month tenancy, they're not on a fixed-term lease, then it would be a 30-day notice if less than 1 year. So you're certainly free to do that.
Okay, so Matthew on YouTube, does the Los Angeles City ordinance only apply to rent control apartments?
No, it applies to any residence. So if you have a single-family home not subject to any rent control, if the tenant in any way breathes the fact that he's not paying because of the virus, then you cannot collect rent. It's deferred. And for 1 year till February 1st of 2022. On February 1st, 2021, you would be able to make a demand for that rent, but as to all rent owed prior to that date, that's deferred for 1 year.
Everybody, we have loads of questions still left over. We'll never get to it, and I know you don't want Dennis to fall over and collapse out here. And you have his phone number. You can give him a call, and that would be great. Also, I want to just let you know that we do have a doubleheader coming up on January 7th. And we've been getting a lot of questions about Prop 19 and how that impacts people. And so that question will be addressed by Ken Ziskin. We also have another topic. It's going to be cost segregation. And you will not want to miss either one of these. So hit that subscribe button and get the notifications going, and get the notifications set up so that you'll be reminded for that. And make sure you subscribe to the free AOA e-newsletter. And again, thank you, Dennis Block, for answering all those questions and presenting for us today. We really appreciate you, and for all of you watching, thank you, and we wish you a happy Hanukkah and a Merry Christmas.